Welcome to Next Alert, the series where we break down real courtroom moments to uncover the legal nuances shaping each case. Today's episode is a special collaboration with our sister channel, Audit the Audit. If you want to see the bodycam footage of the police encounter that led to the trial we'll be examining today, make sure to check out that video on Audit the Audit. You don't need to watch it to follow along with this episode, but it might help give you some extra context. You can find the link in both the description and the pinned comment below. On May 9, 2023, defendant Calvin Riley Sr. was charged in Lyon County, Florida, with driving under the influence and driving with a suspended license. Months later, on February 16, 2024, Mr. Riley's attorneys filed a motion to suppress seeking to exclude any statements their client made before he was read his Miranda rights, as well as to exclude a liquor bottle discovered in his vehicle. That bottle had been opened and partially consumed by Officer Kirsten Oliver of the Tallahassee Police Department, raising questions about evidence handling and procedure. In an order dated February 28, 2024, Circuit Judge Jason Jones partially granted the defense's motion suppressing certain pre-Miranda statements but allowing the bottle evidence to remain. The judge reasoned that the admissibility of the bottle should ultimately be a question for the jury, not the court. Fast forward to April 5, 2024, when the case finally reached a jury trial. Certified legal intern Emma Hershey delivered the opening statement for the prosecution, contending that Officer Oliver's decision to open the bottle was merely an honest mistake and that the signs of impairment were already evident long before that bottle came into play.
May it please the court, defense, members of the jury. It was 2 a.m. and he was driving with no headlights on. It was 2 a.m. and he admitted to drinking alcohol. And he admitted to being at a local bar. Good morning, members of the jury. My name is Emma Hershey, and I'm a certified legal intern with the State Attorney's Office here in Florida. We represent the people of Lyon County. And we're here today because the defendant in this case is charged with two things. First, he's charged with driving under the influence. And second, he is charged with driving with a suspended or revoked license. These are two things that we talked about during jury selection, so I just want to briefly go over what to expect for the state to prove in this trial. So first, driving under the influence. There's two things that the state must prove. First, that the defendant drove or he was in actual physical control of a vehicle. Now, actual physical control of a vehicle, that doesn't mean that you necessarily have to be driving down the road when law enforcement encounters you. All it means is that you have to operate a vehicle, be capable of operating a vehicle. Now, we expect in today's case that you're going to see that this element will be easily satisfied. You're going to see in body-worn camera footage that the defendant was driving his vehicle. So we expect that we're going to establish that element. The second element that we must prove to you today is that while driving or in actual physical control of a vehicle, the defendant was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. This is another thing that we talked about during jury selection. What signs of impairment are. See, you're going to learn throughout today's trial that impairment isn't necessarily falling on the floor drunk or tipping over, struggling to walk. It can be something as simple as your vision is affected when I take my glasses off. It can be something as simple as not being able to follow instructions, struggling to find documents. It can be something as simple as slurring your words. But members of the jury, there's another sign that we expect for you to see in this trial. Anger and aggression and an outburst of emotion. That's another thing to look for as we proceed. The second charge in today's case is that the defendant was driving with a suspended or revoked license. Now, this charge has three different elements that we have to prove to you here today. The first element is that the defendant drove a motor vehicle upon a highway in this state. Now that applies to any roadway really here in Florida. So if you hear that the defendant was driving down we expect that you'll hear that the defendant was driving down Monroe Street when this incident occurred, that he was driving a vehicle. That brings us to our second element. Number 2, that at the time he was operating his vehicle, his license was suspended. You're going to learn in today's trial that the Department of Highway Safety and Motor Vehicles issued a notice of suspension to the defendant. Not once, not twice, but 3 times before he was stopped on May 7th of 2023. They sent this notice to his P.O. box that he specifically requested them to send his mail to. So we expect that we're going to establish that element here today. Third, we have to prove that at the time the defendant knew that his license was suspended. And this kind of plays with element 2. We expect that you're going to learn that because the defendant had access to his P.O. box, he had the ability to know of it, and he had notice of it because he was sent it 3 times in the mail. 3 times. Now the judge is going to instruct you that anything I say during opening statements, and if the defense chooses to give an opening statement, that anything they say should not be considered evidence. What we're doing in opening statements, this is a general guideline, a roadmap as to what you can expect in today's trial. Kind of like painting a picture. So that's what I want to do for you. It's May 7th, 2023. 2 Tallahassee Police Department officers are on the side of the road on North Monroe Street, responding to a completely different traffic stop. And as they're responding to this different traffic stop, they notice a vehicle traveling at a high speed, whipping down the street over the speed limit. And at first glance, it might sound like it might just be a speeding ticket, but it wasn't just an ordinary, usual speeding incident. This wasn't an ordinary traffic stop. Because the issue is that the vehicle was traveling with no headlights on. Like I said, this happened at 2 a.m. in the morning with no headlights on North Monroe Street, which is a busy road. So seeing that this car is driving down the road with no headlights over the speed limit, one of those officers, her name's Officer Kirsten Oliver. You're going to hear from her today, and she's going to get on the stand, she's going to testify about her observations. She's going to tell us about how she hopped into her patrol vehicle and decided to pursue the vehicle, how she had to speed up to try to catch up with it. And as soon as she's finally close enough to finally put her headlights on and her emergency lights, you're going to learn about the defendant's driving pattern. You're going to learn that he was swerving. And when he was swerving, he almost swerved into another vehicle in the right-hand lane. That's finally when he stopped. You're going to learn that, yes, he put his blinker on. He put his blinker on. But did he get over to the side of the road? No. You're going to learn that he didn't get over to the right-hand shoulder. He didn't get over into a safe area to park. You're going to learn that he stayed in the middle of the road. In fact, his tire wasn't completely over into his lane. Close enough that another passing by car could have potentially sideswiped him. Now, members of the jury, you're going to learn from Kirsten Oliver that at that point she got out of her vehicle to go speak with the occupant of it. When she approached the vehicle, she noticed one individual alone inside of it, the defendant. When he rolls down his window, I want you to pay attention to the body-worn camera and look for the signs of impairment. You're going to hear about how law enforcement officers are trained to look for signs of impairment and what specific things can point to alcohol impairment. Members of the jury, what I'm asking from you in this case is to stick to the facts and look to the facts of the case. The facts will guide you throughout this trial and throughout your deliberations. You are sworn to uphold the law and the law alone. The facts are simple. He was driving He admitted to drinking alcohol. He admitted to being at a bar. Notice was sent to him 3 months in a row saying your license is suspended because you don't have insurance. And he still chose to drive despite knowing his license was suspended. He still chose to drive because even though he knew he had drank alcohol. The facts are simple. At the end of today's trial, you're going to hear from all the witnesses who are necessary. You're going to have the opportunity to review evidence and video footage. And at that point, we're confident that you're going to see the truth, that the state has met its burden, that we've proved this case to you beyond a reasonable doubt. Not a mere speculative doubt or forced or imaginary doubt, a reasonable doubt. You will see the truth, and the truth is that the defendant is guilty.
An opening statement marks the first opportunity for each side to address the jury at the start of a trial. It serves as a roadmap laying out the facts and evidence that each attorney believes will be proven during the proceedings. However, it's important to note that an opening statement itself is not evidence. It's simply an outline of what each party intends to demonstrate. In her opening statement, Ms. Emma Hershey, representing the state, worked to downplay the significance of Officer Oliver's mishandling of the liquor bottle, framing it as a simple, unintentional mistake rather than misconduct. She urged the jury to focus instead on the other signs of impairment observed. That night evidence, she argued, would independently establish Mr. Riley's guilt. When it was the defense's turn, Assistant Public Defender Desiree Goodfellow delivered a sharply contrasting narrative. She contended that Officer Oliver had fabricated evidence, falsely claiming to detect the odor of marijuana to justify her actions, and then opening and partially consuming the liquor bottle found in Mr. Riley's car. According to Goodfellow, these actions were not mistakes, they were deliberate attempts to build a case against an innocent man.